Can divorce cases go to the United States Supreme Court? Believe it or not, a few couples have gotten so bogged down in legal issues that the justices were willing to hear these arguments, including cases as recently as 2018. As part of my series on people who represented themselves at the Supreme Court, I previously talked about Mary Greer Conklin, an author and the only woman without legal education to argue at the court. She argued her divorce case, Conklin v. Conklin, in 1920. William and Grace Griffin got divorced in New York in 1924. I've tried to find some trace of these two outside of their legal case, with no success. Even the Supreme Court wrote, "The record abounds in confusing and irrelevant matter." Their divorce went to the New York State Supreme Court, and alimony was set by 1926. That wasn't the end of it, though. Between 1935 and 1938, Grace got multiple judgments on William's failure to pay alimony. But he had moved to Washington, D.C., and felt that the 1938 judgment was made without proper notice, violating his due process. In 1945, the Griffin divorce went up to the U.S. Supreme Court, with William Griffin representing himself. As a reminder, this is 21 years after their divorce. Unfortunately, this was before the Supreme Court recorded arguments, so details of this case are mostly lost. 6 justices supported overturning the 1938 judgment. Justices Rutledge and Frankfurter dissented on parts, and Justice Robert Jackson was busy in Nuremberg. Just over a year after the decision, while continuing to argue pro se in Washington, D.C.'s appeals court, William Griffin died in June 1947. The case identifies a widow, Zelia B. Griffin, so he must have remarried. Let's briefly talk about the most recent divorce cases at the Supreme Court. In 2017, the justices heard Howell v. Howell about alimony interactions with military retirement and disability benefits.
They were divorced in 1991. John was a veteran. He planned to retire from the Air Force the following year. And the Arizona courts, when they were divorced, thought that John's anticipated military retirement pay was community property. And so they divided it 50-50 between the two. But then, more than a decade later, the VA found that John was 20% disabled, and he became eligible for disability benefits.
And in 2018, there was Sveen v. Malin about whether Sveen, who had died in 2011, should have his life insurance paid to his ex-wife.
Imagine that a person buys a life insurance policy and names his spouse as beneficiary. Then he gets divorced, but doesn't change his beneficiary designation. Where should the insurance money go when he passes away?
Now you might be wondering, why have there been no divorce cases at the Supreme Court in the past 7 years? Possibly it matters that Justices Kavanaugh and Barrett, conservative Catholics, joined the court after that year. Or possibly the court decided that these cases were better settled by lower courts. There's no way for me to know. Your guess is as good as mine. If you want to hear more episodes about people representing themselves at the Supreme Court, please like and subscribe. United States Supreme Court rules and practices have changed since these cases. This was a podcast episode, not legal advice.